Ms. Olszewski?
Here.
Ms. Hodge? Dr. Dakey? Mr. Blanchett?
Here.
Mr. Coy?
Here.
Judge Wendelman?
Here.
We have a quorum.
Thank you very much. According to our agenda, the first item is public comment. We have no public or no comment. Okay. Second item is approval of the minutes. And they were sent out. Everyone had a copy. Is there anyone has a comment on it? Mr. Coy.
One correction under 6, the last paragraph says Mr. Coy inquired about the confidentiality complaints. I believe that was Dr. Dakey said that when I looked at the video. Yeah.
Don't know your voices yet.
Okay.
I will amend that.
Okay. Anyone else have any comment on the minutes? Salute, yeah. We have a motion to approve.
Motion to approve the minutes.
And a second?
Second.
All right, we have motion and a second, and so we'll have a vote. All those in favor say aye.
Aye.
Aye. Opposed? Nay? No opposition. Okay, so they're approved. All right. Now, are you ready?
Ready as we'll ever be.
Oh, good. I'm glad to hear that.
We need to note one other appearance. Okay.
Yes, Dr. Dakey, just note that he just came in, and now we will have a report on complaints filed from our legal brain, Judge Wenzelman.
No, I'm just an advisor in that.
I know, but you got a brain.
There was a complaint that was filed, and I think maybe it'd be helpful if I kind of try to go through the chronology of some of these. I guess we were last together back in October, and I think that's when December, I guess.
December,
We just approved
yeah.
the meeting. Then in January, on January 11th, I received from Diane the fact that a complaint had been received into their office the day before. So I came in and picked it up, and I acknowledged receipt of the complaint by phone to the complainant on the same date. Actually talked to the person, and at that time she advised that she might be withdrawing the complaint because she said she had in her mind as to whether or not there was jurisdiction issues, whether or not that was appropriate as far as being filed with the commission here. Excuse me. She also advised that she was preparing a more detailed statement, which did subsequently come in. I advised her that I had commitments for the rest of the week at that time and not be able to get into the actual work on the complaint until the following week. On the 19th, I received an email stating she was withdrawing the complaint, which I acknowledged. So at that point in time, I felt the matter was done. There was no further action on my part, and really had not done any type of other than reading through it a couple of times, hadn't really done any type of work on it. Then on February 1st, I received by email a copy of a whistleblower complaint, which is another section that's at the end of the government ethics. See if I can make reference to it real quick here.
What are we calling the first thing that was
The
filed?
first thing was an ethics complaint.
Okay.
The second item filed in February was a whistleblower complaint, which I think my recollection is it came by way of the auditor's office first. I think it was filed with him with carbon copies sent to carbon copies. Extra emails being sent to
You and I'll have to explain that to. Okay.
myself and I don't know the other individuals, but by means of the email, a copy of being sent to me, I acknowledge receipt of that at that point in time. Clear back when all this began, as I had advised the chairman and the state's attorney's office and people here, I gave up my license, so I am not in a position to give legal advice. I will not go into that type of process whatsoever. So when, due to the nature of the allegations in the complaint, I advise the Chairman Wheeler, and also I think I had a conversation with Mr. Quinn, advised him that I felt it was necessary that we have outside independent legal counsel.
Why did it come from, did you say the recorder's office? Or
Auditor's office.
Auditor's office.
Right.
Why did it come from the auditor?
There's, under the, let me get back to the provision. When there's a whistleblower complaint, again, this is Division 7, Section 2-286. Whenever any officer or employee of Kankakee County reasonably believes evidence exists that another officer or employee has perpetuated gross mismanagement, gross misuse, or waste of public resources or funds, abuse of authority in connection with administration of public program, etc., 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 shall bring these evidence to the immediate attention of the state's attorney, the auditor, or the employee's department head.
Okay.
So that's how come it went that way. And there's some things that, discussion as to ordinance revisions, which is the next matter, and that which I'll get into, that have come to light because of this this whistleblower complaint. But nevertheless, back to the fact that it came from the auditor's office, and that I contacted the chairman's office. Again, outside legal counsel was procured from the appellate prosecutor's office, which is standard process if a state's attorney's office cannot handle it. And through the course of working with the this attorney, the determination was made that there was no jurisdiction for us to be able to consider this whistleblower complaint. The reason being, at the time that the whistleblower complaint was filed, the individual was not an employee of the county.
Was not.
Was not an employee of the county. And again, if you look at the first sentence, of 2-286, when any officer or employee of Kankakee County reasonably believes that they can basically file this type of an action. Purpose, I believe, overall of the whistleblower protection is so employees of a governmental entity do not have to be fearful of losing their job if they file these type of complaints.
Right.
So again, that's the protection that's afforded out there. Again, this individual is, or at the time of the filing of the whistleblower complaint, was no longer an employee of the county.
Was this person voluntarily separated?
I don't really know the complete details of it, and that I know that the person was discharged. I don't know how agreeable it was. Based on what's contained in some of it, there was some disagreement in the complaints with the different things that have been filed. There was some difficulty that was occurring between the department head and the employee. And again, because of the fact that I'm approaching this at the current time as I would any other time that a complaint is filed. I'm not going to be bringing out names, even though the gentleman sitting over here is full aware of who the names are and everything. I'm still going to approach it from the perspective that I don't think it's proper for me to discuss the individual's name out in the general public. However, I will put out that the individual involved was an employee of the state's attorney's office. That is why I felt that it was necessary that outside independent counsel be procured. For two different, I wanted this group to be able to say we had no impact or influence from within the office, and I felt it was advisable for the state's attorney's office that they not be involved because it removed them from being subject to an argument that, they weren't shooting straight. I just felt that it was necessary that independent counsel be appointed, and ultimately Chairman Wheeler agreed with that also. So we are now at a stage where under the ordinance we're supposed to give notice. Well, let me step back again in that I sent a copy of the legal opinion out to the complaint. I got an email back, and basically I advised the complainant that in all fairness to them, and the gist of the decision or the opinion from the outside legal advisor was that due to the fact that this person was no longer an employee, they were not protected by the whistleblower ordinance. Again, I'm not going to give out legal advice. That's not my capacity here, even though it talks about advisor. That's another thing I want to talk about as far as the name of this. I'm supposed to investigate as to whether or not there's a basis to bring an action in front of the Ethics Commission. I advised the complainant that this was the opinion that was given by the outside legal counsel. The response I got was, I expected as much. And in the letter, I had said I was going to give this person 28 days to file a response if they were in disagreement as to that legal determination. The response again I got back was, that's what I expected. I didn't know how to take that. Was I to take that as being, I expected they were going to find a way not to deal with it, or I expected that was going to be the result because that's what this person's own independent legal investigation had determined. So I let it run the 28 days. And right about the time 28 days was running, then I started trying to get a hold of Toby so I could come and report to the commission in this fashion as to what was occurring. Because again, there wasn't any obligation to let the members of the body know anything until we knew where we were at with the investigation. Unfortunately, our ability to communicate, we were having difficulties until I tried the old-fashioned thing of calling our house phone.
Which worked.
What is the time when did this start? How is this?
Well, again, the initial complaint that was withdrawn was filed January 11th. The whistleblower complaint was filed February 1st. So some of the delay was, and again, I guess this is kind of a learning experience, again, causing us to want to discuss things not only amongst this body, but also after this group has had an opportunity to discuss it, but also to discuss it with the chairman and others at the county board, a process to where we can expedite it as far as getting the outside legal counsel if it's necessary. Because, you know, this initially was, you know, phone calls to Chairman Wheeler, and then the process of getting somebody retained, and it all took some time in that. And and I guess I need to note the fact that there were some other allegations contained in this complaint that also were directed toward the chairman. So it was even difficult having that kind of conversation.
The county board chairman.
Yeah, county board chairman. Yeah, not yourself.
Thank you.
Sorry, I did leave that open-ended. Yes, there were some allegations contained in the complaint and the whistleblower action that were directed toward Chairman Wheeler. Again, another reason why I felt that it just should have been completely outside the state's attorney's office as far as the assistance, the legal assistance that was given. But again, even that made it difficult for me having to have that conversation with him, since he's a subject matter of what's contained in the complaint. So it's something that we need to maybe discuss as to how can we create a process to where outside legal assistance can be procured in those type of touchy situations. You know, quite admittedly, the ordinance that we're dealing with, I know when we were looking at the ordinance when it was being drafted, the complainant was involved with the drafting of the ordinance. So the person's fully aware as far as what the contents are. But I think at this point in time, based on the recommendation from the research from the attorney, I feel that, and the fact, first of all, that the person withdrew the complaint, and then secondly, based on the analysis and legal opinion of the outside attorney, stating that we don't have jurisdiction, it's my determination that, or my recommendation, I'm sorry, that notice should be sent to the person saying investigation is closed, no further action is going to be taken.
Well, I think, Mr. Wenzelman, you did exceptional work on this. It was a difficult complaint to start with, and the outside legal advice was very good. And what I think in our case, in our responsibility, would be if there was any question about this, to continue on. But there doesn't seem to be any question about the validity of the resolutions that were drawn. Yeah.
Well, here's the next sticky wicket that, I'm sorry, can't get comfortable. Sticky wicket that came in yesterday afternoon. Of course, I didn't see it until about I don't know, 7:30, 8 o'clock last night when I finally sat in front of the computer. The complainant advised that that they had learned from a report at the Daily Journal that the county does not believe the ethics complaint I filed were closed. I guess it's a learning experience for everyone. To that end, when the committee does close the complaints due to the lack of jurisdiction, I want to exercise my right under the ordinance to have the ethics advisor refer the complaints to the appropriate agency. I don't know if that would be the U.S. Attorney for the Central District of Illinois, because of the alleged misuse of public funds by a state official, or to the Attorney General or the Office of the Executive Inspector General, or all three to determine the jurisdiction, but I wanted to give you the heads up that I will now be requesting that. So again, here's where we're at. You have an individual that filed a complaint, withdrew the complaint. You then have an individual that files a whistleblower complaint, but we don't have any jurisdiction on it. Are we then obligated, or is the commission obligated to send that on someplace else?
Well, if she feels that that's where it should go, why does she not do that?
I guess there is a provision under the ordinance that, suggests that if a determination is made that we don't have authority, then I should refer it to this agency. Here's the difficulty. Again, it puts me in the position, I first of all would have to do all the investigation to make a legal determination that there is a basis for a complaint to be filed against, with another entity. Again, something else I think we need to look at as to the contents of the ordinance.
Well, would we be obliged to make that determination? I mean, if she is the complainant and is saying that this is where it should go, then I think our only decision is, do we put it in an envelope and send it to them, or do we tell her to do it?
Well, that I don't know.
Yeah, but I know you don't want to spend the time or have the feeling that you can be responsible for that kind of a legal investigation.
Right. I don't have the wherewithal, whether it be license, legal research tools, etc., and I guess, quite frankly, the time.
Well, that's right. And is the first complaint that she withdrew, that's sort of a moot question because she did not refile it, right?
The contents of what were in there, most of what was in there was also contained within the whistleblower complaint.
So she sort of did refile it.
Right. I guess my thoughts on it is, if there would be an obligation on our part to take further action with it, then any time, let me start over again. If a person files a complaint and it's rejected, and let's say there's no basis to it whatsoever, but then that person contacts you and says, I want this referred to the appropriate agency, that then places us each time to have to research everything. And
well, I don't understand why we would have to research everything.
well, it's,
if it needs to go to another agency, they need to do the
well,
research.
that's the problem. Our ordinance right now, and I don't know if I can find it right off the top of my head, basically suggests that we should refer it if we make the determination that there is a
legitimate complaint.
Yeah, a basis for some type of further action that should be taken by someone. And again, that's something we're going to have to look at in that when we readdress it in that. But right now, I have no documentation from outside legal counsel that says that there was any basis to the allegations of the complaint. Therefore, I have, even if there is again, the decision to us was based upon jurisdiction. That we just don't have jurisdiction, therefore we can't proceed.
Right.
The outside legal counsel was not requested to research whether or not there is any validity or not to the allegations of the whistleblower complaint. Therefore, we don't have any basis. I don't have anything to convey to you that suggests that there is some viability or there's some validity to this complaint. I don't have anything at all like that to suggest one way or the other that basically says, I think there's something there. Or I can't say, I don't think there's something there.
No.
But I don't have anything at all to basically give to you to make the determination of referral.
And basically, if I remember correctly, all it is in the complaint is this listing of possible problems.
Correct.
And did they not have, if I remember correctly, did she not have some contact with another agency that would be, county department that would be involved in that?
Well, the whistleblower complaint was filed in the auditor's office. If there's a misappropriation of funds that is taking place, then presumably that would be something the auditor would be looking at.
Well, that's what I'm saying. If they've already seen it, maybe they need to discuss that with us.
Oh, okay. Well,
But we don't seem to have any jurisdiction anyway because she's not an employee.
correct.
So,
So I guess my perspective at this point in time is that a communication would be sent to her, advising her that, you know, because of lack of jurisdiction, no further action be taken, and that we have nothing to base referral to another agency.
If a referral was made, does that in any way imply that we think there's some merit, or can it be, so we're just passing it on without an opinion? Or, I mean, it seems to me
Yeah.
like if we pass it on, we're wasting people's time if we think there's not adequate merit.
And again, I think that's the difficulty that could arise is if every time a complaint is received, and we're asked to pass it on to another entity, is there not some type of requirement that we have a basis or a reason why we're referring it to this other entity?
which would require this legal delving that, you know, you're not interested in doing, or probably legal to do, I don't know.
If any of it that I did right now would be for my own personal curiosity, and not that you know,
Right.
I would pass it on to anyone else in that.
Well, if I just, it seemed that also there's some area of choosing in this particular thing as to what was to be done with the funds. You know, it.
Yeah, and again, that's a whole issue
Mhm.
that I'm not personally aware of in that, but you know, you hear things through the grapevine that, you know, there has been maybe some discussion that have taken place about these things in the past, and that
Oh, right. She did say that.
you know, from my prior years from sitting up where you're sitting at the current time in the 7 years on this board, I know there are certain parameters about how different funds can be used. And, you know, Dick Winkle, who was the auditor at that time, you know, was very, you know, every T had to be crossed, every I had to be dotted, et cetera, in that. I don't know where things are. I mean, that's
Well, we all know.
25 to 30 years ago. So I don't
Right.
know, you know, things change as far as the rules, the regulations, case law that maybe interpreted things. That's how come I'm not in a position to say,
Right.
yeah, I think there's something here or there isn't, because I haven't researched or looked at it. And again, I'm not in that position to give that type of recommendation to this group.
Well, and that's also saying that we don't know, as you are saying, exactly how discretionary funds can be used And
Well, and again, as to the question of referral and just trying to look at the overall picture as to how to proceed in the future. Do we want to be in a position, or does this commission want to be in a position where somebody can raise an allegation, however general or how specific, but with no maybe no legal authority specifically cited, but if there is legal authority cited, this commission doesn't know one way or the other without legal counsel.
right,
Is there some validity to that? It leads me back to the situation where the commission, I think, whenever there are complaints that are filed, are going to need the assistance of legal counsel at times, which under the ordinance is normally going to be the state's attorney's office.
right.
This situation is, because of the parties involved, created the dilemma to where the state's attorney's office really couldn't be directly involved.
Right.
And again, it's food for thought of something that we need to address in the future.
Well, and we have to consider if we need to hire, and it would be probably on a hiring basis, legal advice,
Mhm.
that could become an expensive thing.
Mhm.
I mean, $5 an hour or something at least, you know.
I guess I could say you get what you pay for.
Yeah, Lenny Sachs said that often.
Now we are typing ourselves or dating ourselves.
Clarification, if, in this case, we decided to make a referral, does that create a precedent? Is that what we're trying to avoid, if we will? If we think it's unnecessary, if we did it in this case, then anybody in the future would expect the same, is that?
Well, that's part of it, but I guess I'm thinking from your perspective, do you want to be perceived as an entity that willy-nilly hands things off without really having a basis for, you know, if you're going to be sending a letter to the Attorney General or a federal prosecutor, do you want to get in a be perceived as somebody that just constantly is sending stuff that, you know, they're going to tube almost every time that it comes into their office? Or do you want to be perceived as an entity that if they've taken the time to send this to me, is something that we need to look at?
But that also says that as the complaints come in, you do make a judgment about whether or not you should proceed in investigating,
Mhm.
you know. And I would have a tendency to think that it would be more often than not something that you could ask the state's attorney's office to do, because it would not be
Correct.
involving them.
Normal scheme of things, the way I perceive how we all operate together is a complaint is received. I receive that. I investigate it. It's different than doing legal research on it. If there's issues that arise during the course of my investigation, then I would contact the state's attorney's office and say, this is something I need some guidance on as to, I think is a legal issue, not an investigative issue.
Right.
Then once all that is compiled together, then through the, looking at the ordinance, it's a question of sending it to, or presenting it to this body, my recommendation as to whether or not you should proceed or not proceed.
One of the words that they use in the our little law is gross, you know. So now do we say, well, if you're a whistleblower and you're saying that some officer in the county spent $100 in an area I didn't think it was proper, is that gross? Or do we say we would look at it if it was going to be $40,000 or it was going to be $100,000? You know, I think maybe that's something we should discuss as to changes in it, to be more specific, which might help.
Right. And once we get by this, you know, again, the next item on the agenda is discussion as far as potential changes, which quite honestly, we're going to need the state's attorney's office to be involved with.
Yeah.
But I guess, you know, and I kind of anticipated they might have been here, but then again, once I saw they weren't here, I probably understand why they aren't here. It's, you know, they probably wanted to keep that hands-off approach, which I understand. But I eventually, you know, today yet, I still want to go through areas that I feel that things need to be addressed, and we may have to set up another meeting where then the state's attorney can come in to have the discussion with us.
And how many ordinance revisions do you really think there needs to be, or do they need to be a general classification, a definition as to, you know, whistleblower on a money basis? What are we talking about?
Well,
You know.
if we could maybe say that to the next one.
Yeah, that's
I
what I'm
guess
saying.
if to the next agenda, what I'd like to do is just see what the commission's thoughts are, or if you want to take formal action on it. As far as
Well, my personal opinion is that since we've been advised by outside legal, a lawyer, you know, who seemed to know what he was doing and whatnot, that this particular complaint is not germane for us because it was made by somebody who is not employed, and that seems to, for us, end the situation. The question just becomes then, do we send it on, right?
right,
The complainant would have the right to do it on their own, right? They could send it out.
we definitely.
Right, okay.
And this person is knowledgeable in law, and
Well, I'd recommend that we don't pass it on. I'm making a motion. I don't know if we need a motion.
yeah, well, I would think that,
Well, I think you probably need to address two things. Is one, make a determination as to whether or not any further action should be taken on the complaint. That's one aspect of it. And the other aspect of it is there going to be referral to any other entity.
well, let's address that first issue. If you want to make a motion determining whether or not we should do any further work on that particular complaint.
I would move that we do not do any further work.
Oh, wait, which is he?
I would prefer that we not do any further work, especially given the fact that there's been competent outside legal advice.
Is there a second to that?
I have a question. Was this person with the?
We need the second before we have a discussion.
What's the question on it?
Yeah.
Oh, he
yeah,
needs
but-
a mic for,
Oh, what is
Was this person a former employee or no?
well, first of all, I guess you wanted second that,
we do need a second before we can
All
do
right,
that.
I'll second the motion.
Okay.
all right, then the
Seconded by
question.
Mr.
The question
Blanchett.
was this person a former employee or never an employee?
Former employee.
Former employee, all right.
Any more discussion, questions? Does everyone understand the motion? That we would end our action on this complaint based on the fact that we do not have jurisdiction as given, that information given to us by competent legal. All those in favor, say aye. Aye. All opposed, nay. Okay, the ayes have it. So we will be done handling this. Unless it comes back in our dreams, right?
Just a brief recommendation. Can you just, since it's a small group, please leave all the mics on if you feel comfortable with that, because on the streaming I cannot hear some important
Okay.
stuff. If it was a large meeting, I'd say not to
Yeah.
do that. But I don't want anybody.
Not
You've been back there listening to us?
Now, the second issue as to whether or not we should refer this complaint to another office as was suggested by the complainant. Anyone got any, we would need a motion to not to, if you want it that way, or if your motion is to not, then you have to vote yes.
I'll make a motion that we do not refer this on to an additional agency.
Is there a second?
Second.
Mr. Coy, that we do not refer this complaint to any other agency. Any questions? Discussion? All those in favor of this ordinance?
Motion.
Motion.
Aye.
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 Any opposition? All right, according to our vote, then we will not send this particular complaint on to any other agency at this point in time.
Well, and I guess I'll state openly, I will convey this to the complainant by email. This is the other difficulty with through all the years, I've always had either a secretary or a clerk working with me.
Yeah.
The person has responded in that fashion and acknowledged receipt of things in that fashion, so I will advise the individual in that fashion. But again, with that being done, as we segue into the next item on the agenda, if we can, I'm going to need some assistance probably at times, probably for communications.
I understand that.
And that may be, I don't know, that may be somebody in the administrative office or state's attorney's office or wherever, and that
Well, the next item on the agenda is the discussion as to ordinance revisions.
So let me go through some of the things that I found as a result of this. Well, things I guess maybe we need to note, and then maybe my suggestion would be is to set up a meeting, and maybe they could be conveyed over to the state's attorney's office on the issue of ordinance revisions, and then maybe subsequently set up a meeting to discuss them further, but at least give whoever would be assigned this task the opportunity to look at them a little bit.
I think that's right too, and I think that we can, as individuals, look at the ordinance and see things that we may now, after having been through this process, might understand why we might need changes.
Well, here's the first if you look at it, you have Division 1 definitions. Then you go into Division 2, you have prohibited political activities and all the subparts. And then you have Division 3, gift ban, and several different subparts. What else is there? There's nothing else that we really, is basically, apparently, the way it's drafted now, to monitor political activity of individuals that are members of the county employ.
Well,
Or-
what is there a ban on
yeah,
county
well-
employees taking part in political activities?
It's just basically during compensated time and things of that nature.
Right,
So,
okay.
I mean, there are a lot of specifics about it here. And there's specifics as far as gifts, having
Right.
to report
There's
gifts.
there's some specifics about you know,
So what I'm saying is,
women, women complaining about being treated poorly and,
well,
I mean,
you
what
mean
is it?
sexual harassment? There's not a section on that.
there's not.
No.
Well, nobody ever did that in the county.
Well, I guess you
Are you volunteering?
I can answer the question.
Oh. Which one is he?
18.
Okay.
The county does have an adopted sexual harassment policy, and it's outside of this process because it becomes a human resource issue.
Okay.
So they make the complaints, and so again, I'm not saying you don't want to address it. I'm just letting you know that we do have something on file and adopted. And it was just had to be redone because of the state law changing. So we
Okay,
just
so
revisited
essentially, the
that.
county has a process for somebody
Yes,
to, where do they go to file that?
they go to human resources,
Resources?
and then if the HR is not available, they file it through the chairman's office, and then I disperse that to human resources and to the state's attorney.
Very good, thank you. Mr. Chairman Wheeler?
But again, the issue is, right now, as I look at this ordinance, there's only two things specifically contained in it that we're to deal with.
Right.
Which is
Gifts.
allegations of political activity by employees, worst case scenario during time of employment or during working hours.
Yeah.
The other thing is the question of gifts that receipt, somebody that's working in a department receiving monetary entitlements.
Well, what about this particular allegation of misspending of money? How does that?
Well, that would be in the whistleblower. But
Okay.
looking through this ordinance at the current time, I don't see anything that specifically puts it under the auspices of the Ethics Commission. So that's another issue out there that, again, you have the one section of the ordinance that talks about those two specific things. Then you have an ordinance, whistleblower ordinance, but it doesn't say specifically that. It shows who the report is to be filed with. But again, let me go back. Yeah, it talks about being filed with these other individuals.
Like the auditor and,
Right, the auditor, Okay, well, it says all officers and employees shall be obligated to cooperate during the course of an investigation and comply with the request for information from the Ethics Commission and state's attorney. I guess it kind of suggests that it's in our bailiwick, but it doesn't say specifically that all complaints should go, should follow the processes of the Ethics Commission ordinance. And, maybe it's just some language like that may specifically put it there.
Yeah. well, I think the other item too, like you said about the assistance to you.
Again, if there's necessity of independent legal counsel, and as far as communications that may need to be sent by the ethics advisor. Which, as I say that, again, advisor, and I sent this out way back when we started working on this, that I had difficulty with the designation as advisor, because again, that suggests that I'm going to be advising as far as legal issues and that. I
What
guess,
should we call you?
well, I don't know if you want to put it administrator, investigator, officer, actually officer, ethics officer, something other
There was
than.
something that they said, I thought, in one of, maybe the first copy of the Ethics Commission, where,
There
who
is
does the complaint get filed to? You got an answer? Okay.
The original ethics ordinance as was drafted as you heard by the person who filed the first complaint, it said the state's attorney is the ethics advisor.
Okay.
I asked to have that changed because what if it was somebody in the state's attorney's office that filed the complaint? It was provided back to the individual who wrote the ordinance, and they changed it, but we have since realized that the state's attorney is not an employee of the county, and only ethics violations against the state's attorney can be made to the courts in Springfield. And I may be a little bit off on the specifics, but it has to be made with the other ethics, okay, because they're not an employee of the county. Hence, we're in this weird spot right now, and I think that's what Ken's talking about here. And so when we talk about ethics advisor, 9 times out of 10, and I hope never again do we have to go through this, but if we do, and it involves the state's attorney's office, it requires an outside counsel.
Right.
So I just want to provide that, how this all came about, because when we wanted to do this and do the whistleblower and put it through the county board, it was the intent in removing me and the state's attorney from having anything to do with this process. But what we didn't realize, and we weren't advised by the individual who wrote this, is that the state's attorney is not subject to this ethics complaint process here on the local level, only to what happens in Springfield. And I hope that makes sense the way that I say that. So.
Another thing that's contained in the ordinance at the current time, and I just recently passed this on to Mr. Quinn in the state's attorney's office, is all of those that have served on a public body before. Remember the none statement that you used to file? You know, none. Every answer was none.
None. Yeah. Financial
statement
thing.
of economic interest.
Right.
Okay. The ordinance is drafted at the current time says that I'm supposed to review those.
Mhm.
I haven't seen one yet. I believe they're due May 1st. And believe me, I'm not looking forward to sitting there. I don't know where they're going at the current time, where they've been filed previously. Okay, and see, right now, it says I'm supposed to be looking at those. I don't know if it's necessary. I don't know how many of them you get. But again, I think that's something that we need to
If there be
clarify.
any other answers than none.
Yeah,
Yeah.
so
Well,
that's
first of
one
all,
thing that's in the ordinance at the current time.
Pick out the name you like the best.
Well, I guess if I'm going to continue looking at the none statements and do the investigation, then maybe it should be administrator. It's kind of an administrative type of capacity.
Okay.
If it's if those things are going to go by the wayside someplace else, and it's going to be more of investigation, then maybe it's ethics investigator.
I worry about it, the title investigator, in terms of your feelings about, you know, the law license and all that, you know. But if you like being an investigator.
I've never been sworn in with had a badge or anything either of that.
No.
So, I mean, an administrator is fine with me in that, or something of that nature.
So, which kind of makes sense. Ethics Commission Administrator, because you're going to make the decision as to whether or not the complaints should be distributed to the rest of the members, right?
I perceive that probably in the majority of instances of things that are brought to me. I mean, if it's something, I guess, that's completely frivolous, you know, I would report it and probably not do much of anything with it.
Right.
But the vast majority, I'm probably going to be in a situation where we're going to sit down and have this discussion of that. As far as complaints that are filed.
And if they're a hefty complaint, it should be that we would get some kind of legal counsel, whether it was the state's attorney's office or somebody outside of there, before we made a decision. Because I think we have to be very careful, as since the complaint was given to the reporter, you know, we have to worry about, and we're saying that what was in it was not applicable or whatever. How do we protect the names of people who have been spoken about, although nothing has been determined or even suggested that they actually did anything truly wrong, you know, so.
Well, just as, and I'm not suggesting that this is what's occurring here.
Yeah.
Okay. But just as I don't think a newspaper reporter would want to be used by someone to do their work for them, I don't think this commission wants to be in that position either.
As a newspaper reporter, I tell you that if you get something in which you delve a little bit or talk to the complainant or whatever, and you think that there's something to suggest that it's not being handled properly, you would deal with it as best you could. But, you know, again, we don't want putting out people's names of any kind, either the complainant or the person about whom they're complaining, when there hasn't been any investigation into it or anything that triggers an investigation. And I understand totally what you mean about being used, because God knows we get used.
I never did
you know.
that to you, Toby.
Huh?
I never did that to you.
No. That's true. That's true. But you do have people off the street who, you know, have to tell you about this terrible thing and it's wrong and blah, 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 and, you know.
Believe me, through this whole instance, I have made every attempt for both the complainant to feel that they have been treated fairly, as well as the subject matter of the complaint to be treated fairly in that. I guess I perceive it as trying to fulfill my role just as I would have attempted to fulfill it for the last 22 years while I was sitting on the bench. You know, it's not me to make that final decision. In many of these cases, it's for somebody else to make the decision. You know, if there's a jury there.
There has to be some indication, and you're a good person to make a judgment about that. And this whole thing is judgment, unless it would go into a court situation. And it's obviously not, in our opinion, meriting a further investigation or a legal.
The last item, as far as a concern that I had, that I had voiced way back when we were putting the ordinance together, is that the ordinance, and I'm sure this wasn't taken out in that, but provides that the ethics officer shall prosecute the complaint. And again, this has been my primary concern on that, and
I think if we change the title to administrator, then it will be the ethics officer's duty to administer it.
well, but see, right now, the way that it's, yeah, it's section 2-258. The ethics advisor shall prosecute the complaint before the commission and carries the burden of proving the allegations against the respondent by preponderance of the evidence.
Excuse me.
That again puts me in a position as being a prosecutor, which.
And I think in that it's referring to the state's attorney.
Well, but right now it's the language is myself. What I had proposed clear back in. I guess I sent this to Well, several people were involved in the communication of that, but included Mr. Quinn and, interesting enough, or the complainant. But what I proposed was that I said basically prior to the prosecution of the complaint, when we get to the stage where there's a prosecution of the complaint, it appears that the advisor officer is expected to do, I'm expected to do would be administrative review of ethics statements, which I previously discussed, or investigate the possibility that a complaint should proceed. I suggested that an alternative approach would be, once the investigation is completed and complaint has been allowed to be filed, the further procurement of information at hearing and the making of the record would be conducted by members of the commission after they received all the information requested via documentary evidence or live testimony. They would then be required to issue the decision. They would need to conclude that the evidence had proven the complaint by preponderance of the evidence before they could take disciplinary action against the respondent. So a suggestion I made at that point in time was that, all right, I've done the investigation. I feel that further inquiry should be made with an opportunity to be heard before the commission. The commission could request additional people to attend, could allow for live testimony to be provided. You basically would be sitting in bunk together, hearing what's being presented. You would have the investigative information that I would procure. You would allow the complainant to come in if they wish to do so. You could call in other people. You would then make the decision. So I don't know if there's really a need to have somebody that's actually there prosecuting the case.
Right. Especially when we feel if it gets to that point, we're going to have whatever legal authority we need, you know, either the state's attorney or outside.
Correct. But those are things that have been there from the beginning that I feel are still there, as well as other things that I feel have been brought up due to what has been filed.
Well, I think that's all that is a matter for thought. I think that your problems, you have made those clear to Quinn, right?
Yes.
And so he should be aware when we notify him that we are going to have this other meeting at which we're going to talk about changes that we feel need to be made, revisions. So what we need to do then, I do believe, is establish a date for another meeting. All right, everybody pull out your calendars. What kind of time frame do you think we're looking at? You're going away, right?
Now the whole county knows, Toby.
But I didn't ask the dates. And you can't write, you know, Wenzelman will be gone from.
Yes, I will. That I would suggest probably. I don't know what Mr. Quinn's workload is at the current time, and what his vacation. Hopefully he's going to have the opportunity to have some summer vacation and that too, but maybe a 30-day time frame.
Yeah, that sounds.
I mean, hopefully we won't have anything else show up between now and then, but we'll do the best we can.
Yes. Today is July 3rd. So are we talking possibly August something?
Yes.
Okay. Can we talk about, is a Tuesday acceptable to people?
Works
Is
fine with me.
Tuesday's all right? The 7th, August 7th? And, you should plan on it being not a 15-minute meeting, right? Oh, okay, we can do it a little earlier if we wanna make it 10
That's fine.
o'clock. I don't move much before 11, but 10 o'clock. Yeah, is that all right?
That's fine with me.
I'll check with the state.
Yeah. Well, that's true too, I guess.
Yeah, if you can just, yeah, that would be fine with me and that at the current time.
Okay,
And if by chance I get back home and find
yes. I
something on
know.
another calendar,
Well. Okay. Thank you, dear. Alrighty.
Yep.
Anything else? Other business? Anyone have additional business? Old or new business? I always like to give the press time to speak if they have a problem. That's what I like. Okay, then I think we can be adjourned. Oh, we need a motion to adjourn? Isn't it enough if I say no? Okay. Coy's got a motion to adjourn.
Second.
Dr. Dakey says second. All those in favor say aye.
Aye.
I thought a motion to adjourn too was not negotiable. You can't have an aye.